Hey y'all, we've already made Gary with Tennessee Stands, and we've already made a couple of posts on our social media channels. But some look, it's not often. You all know it's not often that you have a day like today where you win, even if it's just a little bit. You win in the courts, and you have a little something to celebrate. But look, today is a huge day. Two huge court orders just came down today in terms of requirements for the jab from federal contractors and CMS. So per a federal court ruling out of Kentucky and a federal court ruling out of Louisiana, which we'll get into in just a little bit here in just a minute, healthcare workers in the state of Tennessee are now protected. It is now illegal in this state. They are subject to state law. The CMS rule cannot be enforced. It's been enjoined by the court. And it is now illegal for these hospitals to force you to get the jab as a condition of employment. Secondly, per a Kentucky federal order, it is now illegal for federal contractors to enforce any kind of requirement for the jab. As those federal contracts, luckily for us, the order in Kentucky was not a national stay. That order only applies to Kentucky, Ohio, and Tennessee. So luckily, in terms of federal contractors, Tennessee was a named plaintiff in that particular case because the judge only enjoined the federal contractor piece in those three states. So let's just let's take a moment really quick and let's take a look at that. So here is the case out of Kentucky, again, which thankfully our attorney general filed, and Kentucky is a part of this lawsuit. I want to point out something that I thought was a little concerning about the judge's ruling. And also remember that this is a victory. So don't mishear me. It's a victory. We should all be celebrating. Yay, cheer. For now, you're protected. Not saying otherwise. What I am saying is keep in mind that in both of these cases, the court has presented or ordered an enjoined the law and granted, that's the word I was looking for, granted a preliminary injunction, not a permanent injunction. A preliminary injunction. There is still a hearing to be had. The court is yet to make its final determination. And as we all know, in the courts, there's all sorts of shenanigans that can happen. However, it's a great day today that at the very least, the court granted the injunction. And as of today, these activities are illegal from these employers in the state of Tennessee. But let's look at what this federal judge had to say in terms of federal contractors. He said, this is not a case, I didn't like him saying this. This is not a case about whether vaccines are effective. They are. Okay, so we know where this judge sits on the whole vaccine thing. Nor is this a case about whether, this is the scary part, nor is this a case about whether the government at some level and in some circumstances can require citizens to obtain vaccines. It can. So I just want to point out that this federal judge still believes that a government can mandate the shot over its people. You know that we wholeheartedly disagree with that assessment, but that's this judge's thinking, which is why it scares me in terms of a permanent injunction. However, he does go on to say, the question presented here is narrow. Can the president use congressionally delegated authority to manage the federal procurement of goods and services to impose vaccines on employees of federal contractors and subcontractors? In all likelihood, the answer to that question is no. So what this judge is saying is that, look, you can't make performance on a contract. You can't make a condition the requirement of these vaccines as a condition of performance on a contract. So at least he's saying that. But again, it's concerning to me that he's perpetuating the idea that, oh, vaccines are safe and effective. in terms of this COVID vaccine. And also, he still does believe that the government can, in some instances, mandate the shot. Also, again, to note, this order on federal contracts is only applicable to Kentucky, Ohio, and Tennessee, but we're one of those states, so thank God for that. All right, let's move to the CMS healthcare thing real quick. This was the lawsuit filed in Louisiana by Attorney General Jeff Landry, awesome warrior for freedom, probably one of the best attorney generals in the country. This is also the lawsuit that Montana joined in to defend the Montana law. Again, I keep saying this. This has been the law in Montana since May, y'all. So, well, look, I know I sound like a broken record, but we could have done this. We could have had these protections in Tennessee a long time ago. This has been law, enforceable law in the state of Montana since May. All right. They joined in on this lawsuit. Here's what the federal judge in Monroe, Louisiana had to say. They enjoined and restrained the CMS mandate as to all, notice the word all, healthcare providers, suppliers, owners, employees, and all others covered by said CMS mandate. But I want to draw your attention to this. The judge actually points out, in terms of a national stay, he says, in addressing the geographic scope of the preliminary injunction, due to the nationwide scope of the CMS mandate, a nationwide injunction is necessary due to the need for uniformity. Also, he stated that he felt that there are unvaccinated healthcare workers in other states who also need protection. So, to clarify a couple of things, the CMS requirement, it is a national stay from a federal judge in the Fifth Circuit in the state of Louisiana. According to Tennessee state law, it is now illegal for any healthcare facility to require healthcare workers to receive the shot. So that's a fact. I want to point out one more thing before we, how long have I been on here? About 5 minutes. Before I jump off here, I want to point out one more thing about the federal contractor piece. I've already heard folks talking about this. As part of the state law that we passed in the omnibus bill that gave federal contractors this exemption, that exemption was any exemptions that have been handed out thus far to federal contractors were granted by the comptroller of this state. That's Jason Mumpower. And the question mark is that the comptroller has already issued these exemptions. So regardless as to whether or not a court has enjoined the enforcement of this federal contract rule, that doesn't negate the fact that the comptroller has already issued exemptions to state law, which means that the federal contractors like ORNL in the state of Tennessee that already have the exemption, even though the federal judge says these federal contracts and these vaccine mandates are unenforceable, the state of Tennessee has already granted them an exemption to state law. So I want to point something out. Here's what I would say to that. TCA code section 14-6-102, subsection A, which is the section that addresses this, says that the exemption by the comptroller can only be granted in so much as it allows the federal contractor to abide by its contract to receive federal funding. Per this federal court ruling, this temporary injunction, that federal funding is no longer an issue. It's unenforceable. The mandate's unenforceable. So just to avoid any confusion, I just want to say this publicly. I would ask, I think we would all ask, Tennesseans would ask, Comptroller Jason Mumpower, we're asking you right now, per this federal court order, to avoid confusion and secure the constitutional liberties of those federal contract employees in the state of Tennessee. Please nullify and avoid any exemptions that you have already granted to federal contractors in the state of Tennessee in order so that they can receive federal funding. There's no need for an exemption right now. And I think it would be prudent for you to just go ahead and take the step up front to make that statement publicly. Would certainly love to hear that statement. Oh, well, thank you, Brandon. That's an odd comment, but very kind of you. And thank you, sir. And man, I love that guy. Hey, if you guys follow Tennessee Stands, but you should also be following the fine folks at the Tennessee Conservative, TennesseeConservativeNews.com. Follow them, newsbreakers. Love those guys. They're great partners at defending liberty and spreading the truth here in Tennessee. All right, so Comptroller Mumpower, just asking you, sir, take that step, defend liberty, void those exemptions to state law, so that these employees that work for federal contractors are protected. All right, hey, thanks everyone for following. Look, you should. I know it's cold, but you should barbecue tonight. Open up a beer, do something. I am excited for those. Oh, sorry, one more thing. Someone asked the question, what about the healthcare workers that have already been fired? That's a great question, and I don't know what the answer to that question is. Legally, you got fired, and there's no legal, and they fired you under current law, and there's no legal requirement for them to hire you back. I think they would be stupid to not hire you back in terms of the current situation we're in with our shortage of healthcare workers. I think hospitals should hire everyone back. A case in point is Ascension Healthcare, who fired all of their workers on November 12th. And here we are on November 30th, just a couple of weeks later, and now you're protected. So Ascension Healthcare, do the right thing. Do the right thing. Hire these people back who have been doing this for years now, who have been on the front lines, and who we need. We need these good healthcare workers in our state. Hire them back. Do the right thing. Ascension Healthcare, Vanderbilt, and everybody else, do the right thing and give these people their jobs back. Thank y'all. We support you. We're for you. We love you. Go celebrate. Amen. God bless.